Good morning and welcome in the fourth class on sex offences. In the previous class, we have discussed how will you frame your opinion on examination of the survivor of a sexual assault case. Now, in this class, we will discuss the procedure of examination of the alleged accused person of sexual assault, what will be the procedure of sample collection, and how will you opine after examination of the alleged accused person of sexual assault cases. And also in this class, we will also discuss another category of sex offenses. Those are sex linked offenses also. So starting with our first objective, that is the examination of the rape or sexual assault accused persons. So just like 164 ACRPC that deals with the medical examination of the survivor of sexual assault cases, similarly 53 by ACRPC dealing with the medical examination of the alleged accused person. এটা তুমি ওকে মনে রাখতে হবে পরীক্ষায় জিজ্ঞেস করে 164 ACRPC and 53 ACRPC. So 53 ACRPC deals with the medical examination of the alleged accused person. কি বলতে চেয়েছে? প্রথমে শোনো, if a person is arrested on a charge of committing rape, an examination may afford evidence, then a registered medical practitioner working in a government hospital or any other registered medical practitioner in the absence of such a doctor, that means in absence of such a government doctor, any other registered medical practitioner within the radius of 16 kilometers from the place where the offence has been committed, at the request of a police officer not below the rank of a sub-inspector, may examine the person using reasonable force as necessary. So it deals with the medical examination of an accused person by a registered medical practitioner, preferably working in a government hospital. But if there is no government hospital, then any other registered medical practitioner can examine such accused person on the request of a police officer not below the rank of a sub-inspector within a radius of 16 kilometers from where the offence has been committed. And this examination can be done by using reasonable force. What is that? I will come later. So after examination, কি বলছে, the doctor should prepare a report without any delay, giving reason for each conclusion arrived and document the specimens taken from the accused person also for DNA profiling. তার মানে তোমার পরীক্ষা করার পর তোমাকে রিপোর্ট লিখতে হবে and you have to give justification for each conclusion you have arrived for, along with you have to take samples including the samples for DNA profiling. And the report is to be handed over to the investigating officer who then forwards it to the nearby magistrate having jurisdiction over that area. That is 53 by A CRPC that deals with the medical examination of the accused person. So just like the survivor, the summary protocol of the examination includes, the report includes the name of the accused person, stated age, sex, address, brought and identified by the police officer. Now, in case of survivor, the survivor can come directly to the medical officer or can be brought by the police officer. But there is no chance, so far practical aspect is concerned, that the accused person after committing rape will come directly to you and will say that I have committed rape so that you can perform my medical examination. So in all probability, you will face such cases when the accused person will be brought by the police officer for medical examination to you. So brought and identified by the escorting police officer. Next is examination in presence of, that means a disinterested third party of your hospital. That can be a group D staff, group C staff. If you are examining a male subject here in accused person, so here will be the male attendant will be present. Next, assess the compos mentis of the accused person, whether he is understanding the facts you are telling to him or whether he is under the influence of any drug or alcohol. If he is a mature person and of sound mind, he can give valid consent for medical examination. So start assessing the compos mentis, and if found of compos menti, then take a written informed consent. So consent should be taken for examination sample collection. If he refuses, examination can be taken by application of reasonable force as stated in the 53A CRPC. Please remember, if the survivor refuses, then even the police and the court cannot force her for the medical examination, and medical examination cannot be carried out if the survivor refuses to give consent. But in cases of accused person, it is mentioned that even if he refuses to give consent, then examination can be done by application of reasonable force. That means consent is not mandatory in another way. But the problem is that the law has not defined what is reasonable force. এই reasonable force টা কাকে বলে, কতটা অ্যামাউন্টের ফোর্স দেবো, কি ফোর্স দেবো? If an accused person refuses to give consent for medical examination before you, what would be done? Will you slap him, kick him, pinch him, না তার কানটা মুলে দেবে? তুমি as a medical practitioner, you are not in a position to apply reasonable force. And whenever you will tell to the police officer regarding that, the police officer will also say, no, I cannot also apply any force, otherwise the Human Rights Commission will give me a show cause. So the practical rule is that if the accused person is giving consent, you are going for medical examination. If he refuses to give consent, marked as an informed refusal and give a note, the IO is requested to take necessary permission from the court so that examination can be done without consent. Otherwise, you may face the charge of assault on your subject, on the subject. So practical rule, consent dile porikha hobe, consent na dile porikha hobe na, because you don't know what is reasonable force, and as a doctor you are nowhere in a position to give a reasonable force. Eta amader kaj noy. Tahale after taking consent, note identification marks, just like the survivor, at least 2, better go for 3. Next, date, time, place of examination, for example Department of Forensic Medicine, NRS Medical College, on a particular date and time. Next, related to the history of the particular case that is mentioned in the requisition given by the police to you for examination. কি লেখা রয়েছে, ঘটনাটা কি হয়েছিল? And after that, history of his own version of the case is recorded. That means history as stated by the alleged accused person. Now please remember that in the textbook of Professor K.S.N. Reddy, that he has mentioned no history should be taken from the accused person. But we are not supporting the fact. You cannot judge the person coming for impartial medical examination as an accused person. He's an alleged accused person. So, as a doctor, history is very important for us. Whether it's a survivor, whether it's an accused person, or whether he is your patient. So, you must note his version of the particular case. You are not going to judge him. Neither you are going to punish him. So, for you, he is not accused. For you, the woman is not survivor. Here the police is bringing the accused person to you for an impartial medical examination. So apart from noting the history mentioned in the requisition, that is the version of the police, you must note the version of the accused person as history stated by the person. Clear? Followed by general build, height, weight, nutritional status. Dental examination is important for estimation of age whenever there is a controversy regarding whether the accused person is juvenile or not, because on that punishment varies. So the accused person may claim that he is juvenile. So in that case, dental examination is important. Dental counting, eruption of especially the third molar whether erupting or not is important. So dental examination important for estimation of age. Next, clothes. If the police states that it is the same clothes that was owned by the subject at the time of the incident, alleged incident, then the clothes should be examined for any tear, loss of buttons, foreign matter whether present or not, like mark, stains, etc. Hairs, stains like blood stain, there may be blood stain, seminal stains, mark stains that gives an idea regarding the place of occurrence, cosmetic stains like the stain of the lipstick of the survivor, or the stain of the lubricant may be present on the clothes. So external clothing and inner garment should be properly be examined, and it should be air dried under room temperature, and it should be packed inside a paper bag. Clear? And it should be sent to FSL via the police. Now, examination for the injuries over the extragenital body parts. So marks of resistance or injuries present over the extragenital body parts may include anything that can be bruises, nail scratch abrasions, bite marks by the survivor on the body of the accused, if present, should be noted properly. And also, as per dictum, whenever you are mentioning the injury, please mention the age of the injury to detect whether it corresponds with the history of the particular case. Clear? So whether the age of the healing of the injury is corroborating with the history mentioned in the particular case. So for that, injury's healing process or age of the injury must be noted accordingly. So different types of injuries may be present, especially the nail scratch abrasions over the different parts of the body as a way of giving resistance by the survivor to the accused may be found on the body of the accused person. Now coming to the local examination, starting with the pubic hair. So pubic hair should be combed out to collect the loose foreign hair, and that loose foreign hair could be of the accused person or could be of the survivor. So you have to collect the loose pubic hair on combing, and if the pubic hair is matted, then it should be cut out. So along with that, you have to take a control specimen of scalp hair, at least 20 strands, 15 to 20 strands of plucked out tuft of scalp hairs should be taken as a control specimen for DNA. But it is not mandatory if you are taking blood for DNA. Next point is the development of the genital organs with special reference to potency. Though after the Criminal Law Amendment Act 2013, potency is not essential to commit the offence of rape because mere touching is rape, still the question is given by the police officer to the doctor in the requisition and asking whether the person is potent or not. So in that regard, you have to note the general developmental status of the external genitalia. You can go for either Tanner staging of the external genitalia development, or simply you can take a length and the girth of the penis in flaccid state, and after manual or self-stimulation, both length and the midshaft circumference of the penis. Note also the development of testicles. Testicular volume can be measured. Condition of the glans, prepuce, foreskin if present, and frenulum should be checked properly. Now please remember, in cases of forceful penetration against resistance may produce tear or bruising of the frenulum of the prepuce in uncircumcised males, and abrasion on the glans can be seen in both circumcised and uncircumcised males. So tearing of the frenulum is very important finding that indicates the penetration against resistance, and abrasion may be found due to friction in both circumcised and uncircumcised males. So look for the status of the frenulum, whether it is intact and healthy or whether any injury is present over the frenulum as marked in this picture. Next, the penis should be examined for. First is the smegma. What is smegma? You know that it is a thick, cheesy secretion along with desquamated epithelial cells containing also the smegma bacilli. Now, if it is present under prepuce and corona glandis, it is inconsistent with recent sexual intercourse. Why? Because the smegma is rubbed off during intercourse and it takes generally 24 hours for proper redeposition. So look that whether smegma is present or not. But please remember, smegma can easily be washed off by washing the penis. It does not indicate that there is a sexual intercourse within 24 hours if smegma is absent. But you should note whether it is present or not. Next, penis is washed with normal saline and the material is stained with the Papanicular stain. Why? Because the vaginal and the cervical cells following intercourse and from that bar body can be detected that suggests a recent intercourse, vaginal intercourse. So during intercourse there will be deposition of the vaginal cells on the glans penis. If you wash the penis properly with saline and take the material, stain with Papanicular stain, so from that you can identify the bar bodies. Other ways is that Lugol's iodine test. The penis is wrapped with a moist filter paper and this moist filter paper is exposed to a iodine vapor. If the moist filter paper turns brown in color, it indicates a recent sexual intercourse. Why? You know that in cases of recent sexual intercourse when no condom is used, then what will happen? There will be deposition of the vaginal epithelial cells on the surface of the penis, and if you rub it with a moist filter paper, so the moist filter paper will contain the vaginal epithelial cells. Now these vaginal epithelial cells contains glycogen, so the glycogen in presence of iodine vapor will turn brown, which indicates a recent sexual intercourse. So penile wash and penile rubbed filter paper can be examined properly. Next is whether there is any evidence of sexually transmitted infection in form of a urethral discharge or in form of a chancre, chancroid, whether present or not should be noted accordingly. So this is the procedure of examination of the alleged accused person. So after that, sample collection is important. So what are the specimens you will preserve after examination? First is obviously the clothing, if it is the same cloth worn during the time of incident. For any tear, loss of button, hair, foreign matter, stains, that could be of anything which we have already discussed. Next is hair, that is the pubic hair and scalp hair. Pubic hair, if it is matted, should be cut out. If it is not matted, it should be combed out to collect the loose pubic hair. Along with a control scalp hair, minimum 50 to 20 strands should be collected as a control specimen. Saliva may be collected to know the secretor status. If any bite mark is present over the body of the survivor, that can be matched for. Debris under the nail. For that you have to take the nail clippings and scrapings to look for presence of any blood stain, presence of any skin epithelial cells, hair, fiber of any cloth, etc. And it should be matched accordingly with the survivor. So nail clippings and scraping is also important. Next, just like the survivor, you have to take the blood specimen. One specimen, that is the plain vial non-EDTA specimen for blood grouping and drug estimation. EDTA vial for DNA. Sodium fluoride vial for estimation of alcohol when there is a history of performing sexual intercourse or assault under the effect of alcohol. And another plain vial, that is the non-EDTA vial for sexually transmitted infection, that includes a VDRL, HIV-1 and 2, HBsAg. So you have to take the specimen of blood for that. Next, urethral swabs and smears may be taken to look for any sexually transmitted infection, especially the gonococci may be found if present. Next is the swab from the penis. you have to take swabs from the glans penis, shaft and the corona glandis, also from under prepuce, and smear is prepared from the swabs on the glass slide. So penile swabs, especially around the corona glandis. Next is penile wash that can be stained with Papaniculus stain to look for any vaginal or cervical cells for detection of the bar body, and penis can be cleaned with a moist filter paper, can be exposed to Lugol's iodine vapor. If it turns brown, that indicates the presence of vaginal epithelial cells or a recent sexual intercourse. But it does not mean it is the same woman who is claiming to be the survivor in that particular case. But it indicates only the activity, that is a recent sexual intercourse. So these are the specimens you have to collect following examination of the alleged accused person. Now, nowadays the accused persons are very much clever and they are using condom, right? So condoms are used for two factors, so that they cannot be detected. Another is that they also want to protect themselves from sexually transmitted infection. So in that case, from the vaginal swabs and smear you can detect nothing. But one thing is that if you search for the fingerprints at the scene of crime, now what happens during wearing the condom has a particular lubricant that stains the hands of the accused person with the lubricants present in the condom. And if the accused person touches any area, that area bears the fingerprint of the accused person stained with the lubricant of the control. And this type of fingerprint can be detected, the ridge pattern of the fingerprint can be detected by a technology that is known as MALDIMSI, that is the matrix assisted laser desorption ionization mass spectrometry imaging, MALDIMSI, that can map the fingerprint ridge pattern stained with the condom lubricants at the scene of crime. Clear? এটা একটু মাথায় রাখো, এটা একটা recent technique that can be applied. Now coming to the opinion framing after examination of the alleged accused person of sexual assault. এবার আমরা opinion-এ যাব। তাহলে আঙুল তোলা হয়েছে accused person-এর দিকে, এবার তোমাকে কিছু একটা opinion দিতে হবে। The most important question, but is the most obsolete concept to opine on nowadays after the change of the definition of the rape, but still this question is asked by the police to the medical officer considering the potency of the accused person, whether the accused person is capable of performing sexual intercourse. তাই তো? But the issue is not that simple one. এই কোয়েশ্চেনটা কেন দেওয়া হচ্ছে? We are also clueless, but we are tired of explaining that it is not at all mandatory nowadays to the legal authorities. Why so? তাহলে এখানে আমরা opinionটা discuss করব in the form of a question and answer, that is the questions given by the police officer to the medical officer and what will you write in relation to the answer of the particular question. তো প্রথম কোয়েশ্চেনটাই যেটা তোমরা ফেস করবে, they will ask you whether the accused person is capable of performing sexual intercourse. Now please remember that before Criminal Law Amendment Act 2013, sexual intercourse was an essential criteria to commit the offense of rape. But after the Criminal Law Amendment Act 2013, impotence has no bar to commit the offense of rape, as we have discussed, considering the definition of the rape. Slightest penetration of the penis within the vulva That means a mere passage of the glans between the labia majora with or without emission of semen or rupturing the hymen constitutes rape. Touching the external genitalia or inserting any object into the external genitalia is rape. There need not be any intercourse and the act may not be completed one. Actual intercourse করার দরকার নেই to commit the offense of rape nowadays after the Criminal Amendment Act, and the act may not be completed. That means there is no necessity that there will be an ejaculation. So rape can be committed even when there is an inability to produce an erection and ejaculation, and in this regard an impotent and sterile man can also rape. So explain why an impotent and sterile man can also rape. Clear? Question আসতে পারে, explain করবে. So this question must be discarded in the police requisition in each and every case to the examining doctor. এই পোটেন্সিটা কোন ক্ষেত্রে ইম্পর্টেন্ট এখনকার দিনে? It is only important in civil divorce related cases, when divorce is asked by the wife charging impotence of the husband. So impotence is a valid ground of divorce in civil cases. So in that case, determination of the potency of the male person becomes important. It is not at all justified each and every case booked under section 376 IPC. প্রত্যেকটা ক্ষেত্রে এটার দরকার নেই. Only may be relevant when the survivor is giving a history of penile intercourse and the accused person is claiming himself to be impotent one. Right? তখন সেটা রিলেভেন্ট হয়ে থাকবে। যেখানে woman বলছে হ্যাঁ তার সাথে penile intercourse হয়েছে, on examination you may found any injury also inside the vagina, but accused person is claiming himself to be an impotent one. But সব কেসে আমাদের দরকার নেই. Just like the two-finger test in a woman to assess the size of the vaginal introitus to comment whether she is habituated in sexual intercourse, it is as derogatory as two-finger test. And especially when the alleged accused person is not claiming himself to be impotent. সে নিজেকেই বলছে না impotent, then why we are determining the potency of that accused person, right? সে আগে নিজেকে ক্লেম করুক যে I am impotent, then we will decide the potency test. Otherwise, when he himself is not claiming impotent, why we are going to perform his potency test for the sake of examination? And you know that determination of potency is not a very easy task, because it involves our neurological system, vascular system. Anatomy is also important of the particular external genitalia. Endocrine system has immense importance on erection. So, and it is so, determining potency should be a multidisciplinary approach, considering the faculties of medicine, endocrinology, surgery, neurology, and including forensic medicine. And it is a time consuming and requires a lot of investigation, and ultimately everything is found normal, then the case is referred to a psychiatrist for final opinion. Because impotence quadrant, we all know that a person is potent to a particular partner but may be impotent to another person. তাই তো? And moreover, before you, during medical examination, ধরো সিচুয়েশনটা এইরকমই হয়, the accused person কে কোমরে দড়ি পরিয়ে পুলিশ নিয়ে আসলো কোনো কারণে, বা কোমরে দড়িও পরিয়ে না আনলো, এমনি নিয়ে আসলো তোমার কাছে, বাইরে পুলিশ অপেক্ষা করছে, ভেতরে তুমি পরীক্ষা করছো as a man, the person is also a man, and there is also a male attendant. Now it is also unusual that before you the person will get an erection, and before you, if the person has failed to develop an erection, can you call him an impotent? এটাই তো ন্যাচারাল। সে তোমার টেস্ট, তাকে পুলিশে ধরে নিয়ে এসছে, সামনে তুমি দাঁড়িয়ে রয়েছে এরকম জল্লাদের মতো তোমার মেডিকেল অ্যাটেন্ডেন্টকে নিয়ে, সোয়াবস রয়েছে, স্মিয়ার্স রয়েছে, সামনে জিনিসপত্র রয়েছে। So how it is, you can expect that the person will get an erection before you during medical examination in that particular situation. তাহলে তোমার সামনে যদি ইরেকশন না হলো, then you have to refer the case to the medical board, and that medical board will suggest a long investigation that is time consuming, খরচারও ব্যাপার রয়েছে প্রচুর. After that everything is normal, then the case will be referred to a psychiatrist. The psychiatrist also cannot put a specific opinion considering the potency of the subject properly. So ultimately এই ডিসিশনটাই বা এই স্টেটমেন্টটাই দেওয়া হয়ে থাকে আফটার অল এক্সামিনেশন. দেখো প্লিজ নোট দ্য ল্যাঙ্গুয়েজ. There is a negative positive language. So you have examined the patient subject. So external genitalia is healthy, of adult size and shape, everything is normal, no such medical history that is supportive of that there is a chance of impotence like long standing diabetes or any other disease factors. And on self manipulation by the accused person, the penis increased in length and circumference to certain extent and becomes turgid, and this state is maintained over a particular time. So in that case you will opine that there is nothing to suggest that the subject identified as, for example, Mr. X, is incapable of performing sexual intercourse. There is nothing to suggest. We are suggesting nothing that the subject identified as is incapable of performing. তার মানে নেগেটিভে কিন্তু পজিটিভই এলো. এই ল্যাঙ্গুয়েজটা মাথায় রাখো. This is the safest language to opine after initial examination. If you see that following self manipulation, the penis increased to certain extent in length and circumference, তাহলে আমরা তখন সেটাই বলছি, there is nothing to suggest that the subject identified as Mr. X is incapable of performing sexual intercourse in ordinary course of nature. That is very important. You should not miss the term, in ordinary course of nature, on the date and time of medico legal examination. আমি যখন পরীক্ষা করেছি সাবজেক্টকে, আমার এমন কিছুই মনে হয়নি যেটা থেকে মনে হতে পারে he is incapable of performing sexual intercourse in ordinary course of nature. But I cannot write the subject is capable of performing sexual intercourse. That means he is capable of performing sexual intercourse each and every time. For example, if you are desiring a particular woman and for God's sake with that woman you are placed before a Royal Bengal tiger in Sundarban, will you be able to perform sexual intercourse with that particular woman of your choice? So it depends upon time, place and person. Impotence, quad hung is another important factor. So you cannot write the person is capable of performing sexual intercourse directly as your opinion. So indirectly on the findings, if you are getting that findings what I have mentioned earlier, there is nothing to suggest that the subject identified as Mr. X is incapable of performing sexual intercourse in ordinary course of nature on the date and time of medico legal examination. And also you should add that the external genital examination findings suggestive of no hindrance of vulval penetration. Mere passage of the glans through the labia majora is rape. So if you are getting a penis of adult size and shape and have that has no hindrance, that findings has no obstruction or obstacle to penetrate the labia majora at least. And penetration of the labia majora is also rape. So please add that external genital examination findings suggestive of no hindrance of vulval penetration. But if you have any query or question mark regarding the potency of the subject considering either the anatomy of the anatomical findings or the endocrinal factor, or considering the long standing hypertension and diabetes or any other disease conditions, so you may refer the case to the medical board for a concrete opinion considering the potency of the subject. Otherwise this opinion will suffice. And even This opinion is given by the psychiatrist even every report is also normal. তাহলে this opinion is the safest opinion after examination. কিন্তু তোমার মনে যদি কোনো সন্দেহ থাকে যে না, if the person may not be potent, may not be able to actually capable of performing sexual intercourse, in that case you may refer the case to the MSVP for construction of a medical board for particular examination considering the potency. But it is hugely time consuming, অনেক ইনভেস্টিগেশন করতে হয়, accused person কে বারবার পুলিশকে নিয়ে আসতে হবে। And ultimately the psychiatrist's opinion, if everything is normal, it will be the same one. So তোমাকে যদি question করে whether the accused person is capable of performing sexual intercourse, you can write in this way. Second question, whether there is any injury detected on the external genitalia or over extragenital body parts of the accused person. So the answer depends on the findings of your examination. If you are getting injury, you will mention, otherwise you will mention that no injury detected either on the external genitalia or over extragenital body parts of the subject during examination. যদি ইনজুরি পাও লিখবে along with the age of healing এবং কি করে ইনজুরিটা হতে পারে you also mention on that fact. Clear? Question number 3, যেটা আমি সার্ভাইভারের ক্ষেত্রে মিস করে মানে বলিনি, বলেছিলাম যে অ্যাকিউজড এর সাথে একসাথে বলবো। Question number 3, both for accused and the survivor, whether he or she is suffering from any venereal diseases. এখন আমরা venereal disease না বলে কি বলি, sexually transmitted infection. So it depends on the finding of your examination, whether you are getting a evidence of sexually transmitted infection, for example micropurulent urethral discharge or chancre or chancroid over the external genitalia. In that case you will mention. Otherwise, if everything is normal on clinical examination, you can write in this way that clinically not suggestive during examination. Clinically not suggestive during examination. However, final opinion over the issue will be given after receipt of report from state FSL over preserved and sent urethral swabs and urethral smears through local PS along with the blood report. So যে তুমি blood পাঠিয়েছিলে for HBS, AG, HIV1, HIV2, VDRL আর urethral swabs and smear পাঠিয়েছিলে, তার রিপোর্ট আসলে তুমি opinion দেবে। But in medical college setup, we generally send the subject to the OPD of dermatology, that is the skin and the sexually transmitted infection department, for their concrete opinion considering the presence of any sexually transmitted infection, if present then specific treatment of the infection, or whether prophylaxis is required on the part of the survivor or accused. তাহলে you can opine that clinically not suggestive, however final opinion you will give after receiving the reports from the FSL and the blood reports of the preserved swabs and smears and the blood specimens. Or in a medical college setup that we do actually is the refer the case to the department or outdoor of the department of dermatology for their specific valuable opinion considering the presence of any sexually transmitted infection, if present then its treatment, or whether prophylaxis is required in the particular case. They are in a best position to give their valuable opinion in this regard. Clear? Any other point of interest, একটা question জুড়ে দেয় যেটা কিছু নাই লিখতে পারো, or if you have not mentioned the history earlier you can mention the history in the particular section. Mention the specimens you have preserved and sent to FSL, biochemistry department or laboratory with objective of such preservation. কেন রাখছো? For example, I am preserving the blood, EDTA blood, for what? I am preserving the blood for in a sodium fluoride vial, for what? I am preserving nails, clippings and cuttings, for which purpose? You have to give specific reason for each. And if you did not preserve any specimen, depending upon the history of the particular case and the duration between the alleged incident and the medical examination, mention it clearly. That, for example, you may face the case after 1 month, 2 months, 3 months, 4 months. So in that case, you don't require to preserve all the things except the evidences for sexually transmitted infection. তাহলে সেক্ষেত্রে what will you mention? Considering the duration between the alleged incident and the medical examination, that is that days or month after the alleged incident, no specimen of medico-legal significance is preserved except the specimen of blood or urethral swabs and spheres which could be beneficial for the purpose of purpose of investigation. You have to give reason. for that? Why you have not preserved? কারণ তার অত দেরি করে পরীক্ষা মানে স্পেসিমেন কালেকশন করা না করা তো একই ব্যাপার। After 1 month, whether you will preserve the urethra, will preserve the penile swabs and smears of the particular case, that has no bearing with the particular case. Clothing has no bearing for the particular case. তাহলে তুমি কি প্রিজার্ভ করবে? Only your direction will be directed towards the detection of any sexually transmitted infection and also whether it is detected in the respective survivor, so that it could act as a corroborative sign of sexual intercourse or sexual assault, right? So these are the questions and the answers. I will not say the ideal answers, but the answers to that particular questions asked by the police on examination of the accused person. So this is all about the examination of sexual assault cases on the part of the survivor, on the part of the accused person. Now we are going to the second category of the sex offences, that is the sex linked offences. So this is the second category of sex offences, sex linked offences. So under these sex linked offences, there are 5 examples of sex linked offences. So first one is stalking, second one is voyeurism, third one is sexual harassment, fourth one is indecent assault, and fifth one is trafficking. These are the examples of sex linked offences. পরীক্ষায় জিজ্ঞেস করে what are the examples of sex linked offences? So these are the examples of sex linked offences. Starting with the section 354 IPC. 354 IPC কি বলছে? Assault or use of criminal force to a woman with an intent to outrage her modesty. Assault or use of criminal force to a woman with an intent to outrage her modesty. Indecent assault. For that, imprisonment for 1 to 5 years with fine. Clear? This is indecent assault dealing with section 354 IPC. That is assault or use of criminal force to a woman with an intent to outrage her modesty. Indecent assault, imprisonment for 1 to 5 years with fine. 354 AIPC. That deals with the sexual harassment. আগেরটা বললাম indecent assault, এবার আমরা বলছি sexual harassment. 354 AIPC. Sexual harassment বলতে কি বোঝেছো? এটা ভালো করে জেনে রাখো, and especially the woman, তোমাদের জন্য এটা খুব জানা দরকার. What do you mean by sexual harassment? And also for the men, যে তোমার এই আচরণগুলো can be considered as a sexual harassment to a woman. Be aware of that. So what is sexual harassment under section 354A IPC? 1. Physical contact and advances involving sexual overtures. Overtures means proposals. So physical contact and advances involving sexual overtures. Point number 2. A demand or a request for sexual favors. A demand or a request for sexual favors. Point number 3. Showing pornography against the will of the woman. And point number 4. Making sexually colored remarks to a woman. That all comes under sexual harassment. From physical advances to a demand or request, showing pornography and making sexually colored remarks. And punishment for point number 1 to 3 is that imprisonment up to 3 years or with fine or both. And for making sexually colored remark, there will be the punishment for imprisonment that can be up to 1 year or fine or both. So this is about sexual harassment that comes under section 354A IPC, sexual harassment. Section 354 IPC deals with indecent assault, 354A IPC deals with sexual harassment. Clear? So physical advances that comes under sexual harassment. Clear? Next, coming to section 354B IPC. 354B IPC কি বলছে? Any man who assaults or uses criminal force to any woman or abets such act with an intention of disrobing. Disrobing means to take off one's clothing or compelling her to be naked. অনেক সময় দেখবে সালিশি সভা গ্রাম পঞ্চায়েত এলাকায় করে কোনো একটা কিছু পানিশমেন্ট করার জন্য ছেলেটাকে বা মেয়েটাকে পুরো নেকেট করে শাস্তি দেয়। দিস ইজ দ্য act of disrobing that is punishable under section 354B IPC. So if any man who assaults or uses criminal force to a woman or abets such an act with an intention of disrobing or compelling her to be naked, that is punishable under section 354B IPC with an imprisonment not less than 3 years, may extend to 7 years with fine. So compelling her to be naked or disrobing or abetting such an act is punishable under section 354B IPC. So this is the disrobing or compelling her to be naked. Next comes section 354C IPC. Section 354C IPC deals with voyeurism or scoptophilia. Voyeurism or scoptophilia. The word voyeurism is coming from the French word voyeur, that means to see, or in other word the observer. Voyeur means an observer. So section 354C deals with a voyeurism or scoptophilia. It is actually a paraphilia, one type of mental disorder, but under Indian law section 354C IPC it is as an example of sex-linked offences, but it is actually a paraphilia. So what is voyeurism? DSM has defined voyeurism in the form of over a period of last 6 months, that means to diagnose a case of voyeurism the symptoms should persist at least for 6 months. This is the first criteria. So over a period of last 6 months, intense sexually arousing fantasies, sexual urges or behaviors involving the act of observing an unsuspecting person who is naked or in the process of disrobing, that means removal of clothes, or engaging in sexual activity. আবার বলছি, over a period of last 6 months there is an intense sexually arousing urges, fantasies or behavior involving the act of observing an unsuspecting person who is naked. মানে যে সাসপেক্ট করছে না যে তাকে কেউ অবজার্ভ করছে at that moment. So unsuspecting person who is naked or in the process of changing his or her clothes or engaged in sexual activity. I am mentioning the definition given by the DSM, Diagnostic and Statistical Manual for Mental Disorders, not the definition given by section 354 CRPC. সেটা আমরা আসছি পরে. So DSM has defined over a period of 6 months there will be intense sexually arousing urges, fantasies and behavior to look oneself in the process of disrobing or engaged in sexual activity or who is naked. And the person suffering from this voyeurism has acted on the sexual urges, or these sexual urges or fantasies caused a marked distress or interpersonal difficulty. That means the person who is suffering from this voyeurism, this act of voyeurism causes a significant distress in his or her life and impairment to more or less important areas of functioning, and these symptoms should last at least for a period of 6 months to diagnose this case as a voyeurism, and it is commonly seen in males. The voyeurs frequently peep into the bathrooms or the bedrooms of others, and that's why they are called peeping toms. The voyeurs are called the peeping toms because they used to peep into the bedroom or the bathroom of others. That is why they are called peeping toms. Now we are coming to the definition of voyeurism as per section 354 CRPC. এখানেও কিন্তু লোকটাই দোষী. Man is the culprit. A woman cannot be charged for the act of voyeurism for any reason. Right? Because it starts with any man who watches or captures the images of a woman engaging in a private act in circumstances where she would usually have the expectation of not being observed either by the perpetrator or by any other person at the behest of the perpetrator or disseminates such images. তার মানে কি বলতে চাইছে, একটা লোক যে কিনা either watches দেখছে or captures the images of a woman engaged in private act. That private act can be in the process of disrobing or in the process of sexual activity or in the process of bathing. কোথায়? In circumstances where the woman would have the expectation of not being observed by the perpetrator or any other person. মানে মহিলাটা ধরো কোনো বাথরুমে স্নান করছে, সেখানে সে কি মানে এক্সপেক্ট করছে তাকে কেউ দেখবে না obviously, but the peeping tom is looking into the bathroom or taking her images or observing her silently, but the woman has not expectation of being observed in that particular process, in the particular act. So this act can be done by the perpetrator himself or by any other person at the behest, that means on the command of the perpetrator, or the perpetrator or the accused person disseminates, or that means circulates such images of that woman. That also comes under the act of voyeurism. If the accused person or the perpetrator circulates such images, so it also comes under the act of voyeurism under section 354 CIPC, so far the Indian law is concerned. And for that punishment for first conviction, প্রথমবার যদি ধরা পড়ে তাহলে imprisonment may vary from 1 to 3 years with fine. Subsequent punishment মানে দ্বিতীয়বার আবার ওই একই কাজের জন্যই ধরা পড়লো, so imprisonment can be extended to 3 to 7 years with fine. That is the punishment of voyeurism, but it is actually a paraphilia, but is included in the sex linked offences as per Indian law is concerned. Psychoanalysts postulate that a voyeurism may be attributed to a child witnessing episodes of his or her parents engaged in sexual intercourse. There is another term that is known as troilism. Troilismটা আরো ভয়ানক জিনিস, কি বলছে, the person gets sexual gratification by inducing his own wife to have sexual intercourse with another man and observing the same act. So inducing his own wife to have sexual intercourse with another man and he observes the act, that is known as troilism. Next type of sex linked offense is stalking. আমরা stalking নিয়ে অনেক বলি, this is known as stalking, that is stalking. So what is stalking as per Indian law? Section 354D IPC deals with stalking. তাহলে 354 ছিল indecent assault, A ছিল sexual harassment, B ছিল the punishment for disrobing, C ছিল voyeurism, and D is for stalking. এখানেও কিন্তু man is the culprit because it starts with any man who follows a woman and contacts or attempts to contact such woman to foster personal interaction repeatedly despite a clear indication of disinterested by such woman. The woman is giving clear indication of disinterest and she is not interested in that particular person, but the man either follows the woman or contacts the woman or attempting to contact the woman to foster personal interaction repeatedly despite of clear indication of disinterest by such woman. or monitors the use by a woman of the internet, emails or any other form of electronic communication. এখানে ল্যাঙ্গুয়েজটা একটু জটিল ঘটিল মতো, কিন্তু তার মানে বলতে চাই the man is actually spying the woman over internet. So he commits the offense of stalking. And for that, punishment for first conviction is imprisonment may extend up to 3 years with fine, and for second and subsequent conviction the imprisonment may extend up to 5 years with fine. But that is actually stalking, and man is the culprit here also, not the woman. Woman cannot be charged for stalking as far as the definition is concerned. And last sex linked offense is trafficking. That means the human trafficking. Section 370 IPC deals with trafficking, another sex linked offense. কি বলছে? Section 370 IPC defines trafficking as whoever for the purpose of exploitation. Here both man and the woman can be charged for trafficking. Whoever for the purpose of exploitation either recruits, receives, transfers, transports or harbors a person by using threat, force or coercion, by abduction, by fraud or deception, by abuse of power, by inducement, including giving payments or benefits, commits the offense of trafficking. And for that, imprisonment may vary for minimum 7 years to 10 years. So either recruits or receives or transfers or transports or harbors the woman by threat or force or by abduction or by fraud or by abuse of power or inducement by giving payments or benefits is the act of trafficking. This is also a sex linked offense. In relation to that, this is not sex linked offense, তাও শুনে রাখো 493 IPC, that is the cohabitation caused by a man deceitfully inducing belief of lawful marriage is punishable with imprisonment up to 10 years, though Supreme Court has their own recent version considering that false promise of marriage whether will be punishable or not. There is a debate on that, and Supreme Court has its own version considering the particular fact under question. And 498 IPC, enticing or taking away or detaining with criminal intention of a married woman is also punishable with imprisonment up to 2 years. Right. So that's all for this class. These are the references. Again, same. পড়ো, যদি কোনো অসুবিধা থাকে, you are free to ask any question. Thank you. Till then, have a great day.